Hello, this is Jeff Kelly, and in this video, I want to talk about what should a person do who's filed Chapter 13 and Chapter 7. They've completed everything. They've got a discharge of their debts, and doggone it, the creditors keep sending them letters anyway, collection letters. What do you do? Well, in the case of Arlene Roth, she sued the mortgage company and got some money. This recently went up to the 11th Circuit, who laid out some rules for what constitutes a discharge violation and what does not. So in the case of Miss Roth, she had filed a Chapter 13. She had a provision in there, a specific provision, to surrender her house to the creditor, and the creditor let 4 years go by without foreclosing on the house. So what kind of creditor is dumb enough to let a house sit there for 4 years with zero payments and not do a darn thing about it? Answer: Nationstar Mortgage Company. So what happened was, after the case was completed, Nationstar kept sending letters to Miss Roth. Her attorney then notified Nationstar and said, "Hey, cut it out. This debt's been discharged. Please don't do this ever again." And guess what? They did it again. So they sued, and the first go around, the case was settled. I think there was an FDCPA violation and also a bankruptcy motion as well. After the case was settled, a few months later, Nationstar did it again. So Roth's attorney filed another lawsuit. Now, I believe the first civil litigation was settled, but Nationstar decided to appeal whether or not it was a violation of the bankruptcy discharge order. Their argument was that, hey, it was just an informational statement. We had a huge disclaimer. This should not be considered a discharge violation. And Nationstar won in front of the 11th Circuit. Now, I mean, even though they won, you may ask yourself, why in the world would any large mortgage company keep sending out letters to a debtor when they just got sued and they settled it? I can tell you, I've personally seen banks do this before. I have a theory. I don't have any facts to back this up, but my theory is that the reason banks make these dumb moves, and that you think there's no way any human being would be this dumb, the answer is a lot of decisions made by banks are not made by humans. They're made by computer programs. And some of these stupid computer programs don't take bankruptcy into account. And I personally believe, and again, this is just a theory, that a lot of banks have decided it's just a whole lot cheaper to settle the occasional lawsuit than it is to spend millions of dollars revamping an automated system that helps run the bank. So, just my opinion. In the Roth case, the 11th Circuit, they went through bankruptcy section 524A2, which states that a bankruptcy discharge operates as an injunction against the commencement of continuation of an act to collect such debt. So the key word here is collect, okay? And so there were a couple of reasons that the 11th Circuit looked at the letter, the informational statement, and said it really wasn't an attempt to collect. For one thing, there was a huge disclaimer that said this is for informational purposes only. This is not an attempt to collect a debt, blah, blah, blah. If you want to voluntarily send a payment, you can send it this address if you want to. I suspect that the reason they got away with this is because it was a house. I couldn't tell from what I read whether Miss Roth was still living in the house or not. And one of the points that the court wanted to make was that, hey, if the bank wants to communicate with this person to find out if they want to redo the loan or whatever, to stay in the house, it might be to their advantage. There was some talk of that. If this had been a car that had been repossessed or something, I think it might have gotten a different outcome. So as a general rule, creditors should just never be sending anything that could be remotely interpreted as a collection letter to somebody who has discharged the debt in a Chapter 13 or Chapter 7. One other thing that I wanted to emphasize here, if you have received collection letters, or you think it was discharged in your Chapter 13 or Chapter 7, you need to call your bankruptcy attorney. You need to sit down and figure it out. I had a case a few years back that my firm was involved with where the debtor had paid the entire mortgage through the Chapter 13 plan. They got to the end of the case, they were excited, and then a few months later, the bank tried to foreclose on them. We did file a lawsuit against the bank for doing that, and they settled. And a few months later, they started sending out letters again. They didn't restart the foreclosure process, but they were sure strongly hinting at it, and we filed a second lawsuit and settled. But that's what makes me think there's no human beings, there's no way any human being could be that stupid. I suspect, again, I don't know it for a fact, I think it is automated, and if you get any type of letter at all that you have questions about, you've got to consult with the attorney who filed the bankruptcy case. It could be worth, a significant amount of money to you. If you have any questions, don't hesitate to give me a call. 770-881-8449. Thank you.